Welcome, everyone. We are so glad that you were able to join us tonight for our Estate Planning 101 seminar. I wanted to take care of a little housekeeping. If anybody needs restrooms, they're down the hall and to the left. And we're gonna dig right in. I'm excited to introduce to you, we have a great panel of speakers tonight. We have Brian Esch, who is a partner and also executive committee member of DeWitt Law. Brian acts as a trusted advisor to business owners, companies and families, handling a full range of legal issues. He employs a responsive and creative approach to problem solving for his clients' legal needs. He represents individuals and businesses in matters involving estate planning, probate, trust administration, family business and succession planning, and agribusiness. So you probably know somebody who needs something like this if you don't, right? He handles a lot of things. He helps individuals and clients to draft and administer estate plans, preserve family wealth, and protect clients' goals and desires. He also represents farmers and companies in the dairy, poultry, and cranberry industries. His agricultural law representation encompasses real estate, business organizations, and other general legal matters in the agricultural field. Brian's affiliated with many things: Madison Estate Council, past president and past board member, St. Thomas More Society of the Madison Diocese, University of Wisconsin Family Business Center. He's on the American Bar Association and Dane County Bar Association, and he's a youth sport coach. Well-rounded guy. And next we have Maggie, Margaret Brown, who is an associate in DeWitt's Madison office, practicing with the Trust and Estate Practice Group. Maggie works with clients to plan for future and regularly drafts estate plans according to each family's unique needs. She also works with families and trustees to administer estates and trust after loved ones have passed away. Maggie joined DeWitt following a successful clerkship, the Honorable Brett H. Ludwig of U.S. District Court for the Eastern District of Wisconsin. While attending Yale University, she was a member of the Division I varsity women's swimming team. Yeah, that's amazing. And served as a copy editor at Yale Daily News. While studying at Washington University School of Law, she received numerous awards, including the F. Hodge O'Neill Corporate Law Prize, the CALI Award in Business Lawyering. That one caught me, it was almost like loitering. Lawyering, much more important. Excuse me. I shouldn't have done that. A Scholar in Law Award, the Dean's Leadership Award, and a Dean's Service Award. Maggie is also a member of the State Bar of Wisconsin. And last but certainly not least, I'd like to introduce our very own Jenny Sheehan. Jenny is part of our State Bank Wealth Management Team, soon to be Lake Ridge Bank Wealth Management Team. In case some of you got the flyers, one and the same, nothing's changing, just that name. February 13th, coming right up. But Jenny is great on our team. She has over 30 years of experience in trust and wealth management, working closely with clients to provide guidance and solutions for wealth management needs. Her ability to listen, connect, and build a lasting relationship with her clients is as strong as her wealth management knowledge and expertise. She graduated from the University of Wisconsin, Whitewater, and is a certified trust and fiduciary advisor. When she isn't busy working, she spends time volunteering or attending meetings as a board member for the Juvenile Diabetes Research Foundation or the Edgewood High School Athletic Board. So you can hear we have some great talent up here tonight, very knowledgeable expertise, and we're really excited for them to present Estate Planning 101.
Thank you. Again, I'm Jenny Shayan. I'm a trust officer with the State Bank of Cross Plains Wealth Management Division. Currently, we're located on Junction Road. We are in the process of moving. Once we merge together with Monona Bank, we'll be moving actually to the Bridge Road location. But we'll still be local, we'll still be here. I have been doing this, as Lois mentioned, 30 years, so lots of years doing estate and trust management. I recently saw a survey that said that approximately 67% of people do not have estate plans in place, which is a large number. So I'm really grateful that all of you showed up tonight, and hopefully we can help you with learning more about estate planning and the documents that are necessary. If you have any questions along the way, certainly don't hesitate to ask. I am thankful you're all here. I'm thankful we have DeWitt here as well. DeWitt, Brian and Maggie will be doing the presentation. I'll be joining in on it, but I'll hand it over to them now so they can go ahead and begin.
Thank you, Jenny. Thank you, Lois. Thank you all for being here tonight and not going to the Badger game. So, this is going to be an estate planning overview, and we encourage questions during the presentation. I think I find that it's a better presentation if we have some interactive discussion, and I think the questions will help other people in the crowd. We're also going to stay after the presentation. If you have an individual question that you don't feel comfortable asking during the presentation, feel free to come on up and ask us. Maggie and I will both stay, and I know Jenny's going to stay too. And then lastly, if anyone has a desire to have a no obligation meeting with us to talk about your specific estate plan, we're happy to meet with you at your convenience, either by phone or Teams or Zoom or in person. So if you're interested in getting together with us, just reach out to us, and we're happy to get together with you on a no obligation basis. So Maggie's gonna do the PowerPoint, and then Jenny and I are gonna interject. If anyone has difficulties hearing us, just raise your hand so we'll talk louder because we're not on a mic. So this is just a very basic overview. Estate planning is a really, really complicated topic, and our goal tonight is just to touch on some of the issues and the documents. We're probably not going to get involved in a lengthy discussion of estate taxes, but if anyone has a specific estate tax issue that they want to bring forward, a question, just let us know. And what we're trying to accomplish today is just give you some knowledge that you can take back to your own planning and work on your own specific family estate plan, either with us or with someone else. So Maggie's going to talk a little bit about what makes up a good estate plan.
All right, who here has an estate plan right now? That's a few of you. Yeah, I think that's a will. Perfect. All right, so quite a few of you. That's awesome. So our estate plans include more than just a will, though. They often include marital property agreements, powers of attorney for finances, and powers of attorney for healthcare. Sometimes they also include living wills, which are also known as the declarations to physicians or an advance directive. So, a will, as you probably know, governs the disposition of your property after you pass away. That system, where your property is managed, is called probate, and the court oversees probate. It takes some time and costs a little bit of money, and so a lot of times people don't necessarily want to go through that process. And there's ways to get around that, like a trust, which we'll get into later. But the primary way to manage your assets after death is through a will.
So has anyone acted as a personal representative for a family member's estate? Okay. And did they have wills or trusts?
Will.
Okay. Okay. Yeah, and in most cases, people who have a trust also have a simple will that's linked to the trust. So we'll talk a little bit about, what is a trust and how you might use a trust for your estate plan and how that trust would, link with your will.
The distinction between probate assets and non-probate assets is important. So probate assets are the ones that flow through your will. They're the ones that are managed by the court, that your personal representative, who's picked by the court or confirmed by the court, has the power to basically step in your shoes and then manage your property according to your will. That's their job. Those assets are subject to a fee. It's 0.2% of the assets under management, or under management by the court, so it's not huge. The personal representative is entitled to a 2% fee, so just one order of magnitude greater, for their services.
Can I ask a question?
Yeah, of course.
Why would we have to do any of this if we have a personal, a lawyer or something that we would normally go to have the document read? Did you even have to do any of this stuff?
You do, yes.
You
If you,
still have to go through and pay a county 2% of your total?
0.2%, so. So now these are a probate assets. So probate assets are assets that don't have a beneficiary designation, are not jointly titled with another person, or are not in a trust. So
But
these,
most of them are payable on death. I mean, most of everything I have is payable
Yeah.
on death.
Well, then you-
What would you go for probate?
you may not have any probate assets. So I don't know if you have do you have a payable on death designation on your house? Okay. So we'll talk about that later in the presentation, because there are some pros and cons to using payable on death designations as your only estate plan. And we'll identify what those are and maybe talk a little bit about why you might consider other documents. Anyone have any follow-up questions?
so non-probate assets are any assets that pass outside of the court's jurisdiction. And those are your assets that have beneficiary designations on them. Those beneficiary designations act as a mechanism where they are transferred immediately by law after you pass to your named beneficiary. They do not have to go through the court in order to be administered. They just move automatically. So that saves the time and court fees of going through probate.
So some of those examples might be your retirement plans, you have life insurance at work, or a standalone policy. You usually have designated a beneficiary on your life insurance. You may have put a beneficiary designation on your bank account or investment account. And although that's a very effective way to avoid probate and to get your assets where you want them to go, there's some downsides to just using beneficiary designations. We'll talk about those in a little bit. I think Jenny has some comments that she'll want to make about that later. Yes, sir.
Question on jointly held, assets. If the joint ownership is, the verbiage uses the word and, is it different than the word or? And how
Yes.
does that come into effect?
Yeah, so, and means both are, owners, and both are necessary, signers if you want to do anything with that account. Or means both are owners and either one may act or sign on that particular account. Jenny, you wanna elaborate a little more on that from a banking perspective?
Yeah, exactly. So if you have it joint and they both own it, just repeat what you would say, that the or means that it'd be separate then.
Yeah, and usually you would have some additional language that might follow the John Smith and Jane Smith, or John Smith or Joan Smith. It might say as marital property, or as survivorship marital property, or as joint tenants, or as tenants in common, and all of those designations have a little different meaning under the law.
So wills are important for a lot of reasons. That is how you manage your probate assets. As we've mentioned a couple times now, there are ways so that you don't have any probate assets, and that's just fine. But it is still important, especially for those people who are guardians of minor children, because the will is the only place where you can name a guardian. And so when our younger families, or our younger couple of clients come in with children, I always advise them to make a will, because that is where they get to choose who the guardian of their children would be should they pass. Otherwise, the court just sort of has to go through and pick whatever it thinks is best. So it's a really key document, especially for that.
Yeah, I'll step in on that. I had a situation that was very sad with a young woman who had a 16-year-old daughter. She was a single mom. She tragically died unexpectedly, did not have a will, did not name a guardian for her 16-year-old daughter, and that daughter ended up bouncing to 3 different guardians in a 1-year period because there was nobody named, and so there was no obvious person to take her. And so it just ended up being a very turbulent year for this young child, and she was the same age as my son when I was handling her account. My heart broke for her. It's very important that young families who have young children, they name a guardian so that they don't run into a situation like this. And because the woman died intestate and didn't have a will, we didn't get involved until probably 4 or 5 months later, by the time they were able to name a bank and get us appointed. So the property was kind of stagnant for a few months while we were getting appointed. It was a farm, it was horses, livestock, so it's important to have that kind of thing in place so that things are taken care of right at the time of passing.
And so the other thing that you designate your personal representative in your will, and the personal representative is the party that you want to handle your estate after you're gone. So by signing a will, by having a will, you're able to nominate your own personal representative, the person that you would trust to handle your estate after you're gone. And that really streamlines the process if there's a need for a personal representative. So in Jenny's situation, they had a farm, they had horses, they had livestock, and they had no one who was legally appointed to deal with those assets. And so you have it took some time for the bank to be appointed the personal representative, so you can avoid that delay by having your own nominated personal representative in your own will.
So in that case, everything she had, we just didn't have somebody that all was considered probate.
She apparently didn't have.
Right, she was intestate, so it all had to go
Yeah.
through the courts.
So intestate means there is no will, there's no revocable trust, and all of the assets are in probate, and then the law states what happens to the property, and the way the law reads may not be the way you want your property to flow.
Can you have more than one? Can you only have one? Can you have more than one power of attorney?
You can have more than one power of attorney, and you can have more than one personal representative. So you could have co-personal representatives, and sometimes clients will come in and they have a family member that they trust, but the family member may not be very financially savvy, so they will sometimes appoint a bank as a co-personal representative, or 2 family members. Maybe one of your family members is very sophisticated on financial matters, and the other family member, sophisticated but not someone who's gonna move the ball forward, and maybe the other family member will keep the other person honest. So, it's certainly fine if you don't have an obvious person that you wanna entrust with all of the duties. You can break up the job into 2 people.
what I like to tell my clients is that when you name someone, make sure that they have the time, the desire, and the skill set to act in that capacity, because they need all three. It takes a lot of time, they have to wanna do it, otherwise it may be sloppy. And the skill set includes, gathering assets and making sure that they have the investments correct and the taxes correct, and just being a fiduciary on your behalf. You want someone that's gonna take care of things for you. And so, if you're going to name a family member, I often recommend to my clients, if you feel adamant that you wanna name your firstborn son as an honor to be in charge of everything, that's great, but give them an escape net. Give them an opportunity to say no. And you can do that by naming a corporate trustee in the document as well. So if you wanna name your son and then your daughter, but then third, you name a corporate trustee like State Bank of Cross Plains to be personal representative in your will or a trustee in your trust, then all they have to do, your children can just decline to act if they don't have the time or desire to act, and we can step in. But if you don't name us in the document, then it has to go to court. So they're kind of stuck, and then the attorneys have to get involved and get us named, and it becomes a much bigger process versus just putting that escape route in there for them to say, no, I don't have time. Maybe they're dealing with a medical condition. Maybe they, are changing jobs and moving. They just don't have time to handle all that, plus they're grieving. So, just something to think
Or
about.
maybe the siblings aren't getting along.
Family
and,
dynamics.
I
Yeah,
think
forgot that
people,
one.
I find that my clients feel like it's important to name their children. And I think they think that the child will be hurt sometimes if the child isn't named, but I often find that it's more of a burden than it is an honor. And for those of you who've gone through the probate process or the trust administration process, it's a lot of responsibility, and in certain circumstances, it can be a lot of work. Yes?
What is the average time to probate a will?
Well, the court has some deadlines, and the court really, in Dane County, the goal is to have the probate completed in 9 months. Sometimes it's faster than that, and we have probates that close out in 6 months, and in other cases, it's way more complicated. There are parties fighting, there are difficult assets that need to be dealt with or sold, and in some cases, you can have a probate last a year to 2 years.
Yeah, typically in our introduction letter, I will state that the probate will could take anywhere between 12 to 18 months, depending on the complexity. That doesn't mean it's gonna be distributed 12 or 18 months later. It just means that that's when it'd be closed with the courts. We like to do it within a year, but depending on the complexity, if we have a property that we're trying to sell or a farm we're trying to take care of, certain things can take longer to process, so it may take longer. But as Brian said, we try and get them done within a year, ideally, but that doesn't mean we don't distribute some of the assets before then. We usually get the inventory done, file it with the courts, and then try and do an initial distribution as best we can, with leaving a little left over for final taxes and any debts that might come up that we're not aware of. Yes.
During that time, is the law firm involved during that entire 6 to 9 months and possibly a year and a half?
The law firm that is attached to that estate is involved as much as needed. So if we can do it all on our own, we do it all on our own, but we do have them file things, like we prepare the inventory, but we have the law firm file it because it has to be done through the law system now.
Yeah, and I think that what I tell people is we're happy to do as much or as little as you want us to do. So there are tasks that are required, and we identify what those tasks are, and then typically our law firm would divide the tasks with the client. So our client would be the personal representative, and we'd work closely and provide as much support as the personal representative wants, or as little support. If the personal representative wants to do most of the work, we're happy to have them do most of the work.
Yeah, so it really depends on if it's an individual more than a corporate trustee, plus how skilled that person is and how comfortable they are with an attorney doing as much, you know, or as little. Yes.
And what would that hourly rate be on an average?
For the attorney,
So it depends on the law firm that you're working with,
Price
so.
on average.
So on average, I would say that, if you're working with one of our associates, our billing rates might be $275 an hour up to $450 an hour.
Thank you.
If it's your child who is a personal representative, do they, or anybody, do they get paid, or is there some, you know?
Sure. So generally, if the PR is your child, we recommend that they do not take the 2% PR fee because that is income subject to taxes.
Okay.
Whereas if they get their share through inheritance, if they would otherwise, that is tax-free.
But sometimes if you have siblings that are fighting and one child is the personal representative and they're taking a lot of flack from their siblings, they might decide to take the fee, because that then will partly come out of their sibling's share of the estate, so.
and they probably earned it.
It can be a good way, a good incentive to get along.
Yeah.
Yes, sir.
They get reimbursed expenses too.
Reimbursed for
They get
expenses,
reimbursed.
yes,
If
correct.
they don't take the fee, they can still get expenses.
Correct, yes.
And I was asked up here, what do we charge as a corporate trustee if we're a personal representative? We follow the statutory 2% rate, so for our services, it's 2% of the amount of assets that are probate assets. So that would include things, that don't have a beneficiary designation or aren't payable on death. So if you have insurance contracts that pay out to individual beneficiaries, we'll make sure that you're aware of those, the beneficiaries, and that they get the claim forms, but we don't charge for that because they're not under probate management. Does that make sense?
Alright, so we mostly talked about this, but if you don't have a will, your assets have to go through probate. That's the state's procedure for managing your assets. And it goes according to statute. So because you didn't have a will, the law basically determines where your property goes.
Are you familiar with the law and where that would go if you didn't have a will? You wanna touch on that, Brian? You probably
Yeah,
know by
so
the back of your hand.
so intestacy says that if you're married and all of your children are children of the marriage, then your spouse would inherit. And if you have no spouse, but you have children, then your children will inherit. And if you have no spouse or child that survives, and your parents survive, then your parents will inherit. And then if you have no parents that survive, then your siblings will inherit. And then if no siblings, then nieces and nephews and so on and so forth. So in many families, when you walk people through that and you identify the fact that maybe a niece or nephew would be inheriting from them, they don't like that in some instances, so that might be a motivator to make sure that you have your beneficiary designations up to date and you have a will or other estate planning document in place.
Do grandchildren come before nieces and nephews?
Yes, yeah, I'm sorry, I didn't take it down that far, but grandchildren, great-grandchildren, and so on and so forth. And then there's also a special wrinkle that if you're married and you have children that are not from that marriage, but from a different marriage or a different relationship, there's a division of the assets with your children that aren't from the marriage and your spouse.
Right, so we've been talking a lot about beneficiary designations, and it seems like most of you are familiar with what those are. But they essentially get attached to an asset, so on your bank account, it'll say life insurance policies, retirement accounts, things like that. you name a person that you want those funds to go to, and that is your beneficiary designation. And because you have that on there, and it works by operation of law to transfer to your beneficiary, that is a non-probate asset.
Only reminder I would say is, please check your beneficiary designations, because it's easy to forget them, and it's easy for them to be maybe your parent, or your ex-spouse, or someone who's no longer in your life on that beneficiary designation, or someone you don't really want to get that because you filled it out 25, 30, 40 years ago. I had a client, couple that came in, and we always go through all their beneficiary designations. And I said, can you check on this one? We don't know what it is. And he had his mother, they were in their 70s, and he had his mother listed on the beneficiary designation form because he just never changed it, never thought about it. So I would highly recommend that you, if you don't know, please check what your beneficiary designations are and make sure they're where you want them to be.
Years ago, we had a case in our law firm, and we had a client whose spouse passed away, and she had been married for 30 years to her husband. And when she looked into his state retirement account, she unhappily learned that he had designated his ex-wife as his beneficiary. And the state has a very strict rule that even though there was a divorce, that divorce didn't negate the beneficiary designation, and we had to engage in litigation to try to get the surviving spouse's interest in that retirement account. So it's very important, and you'd be surprised how often people have designated someone years and years ago and then just never updated it when circumstances change. Yes, sir?
So how did that litigation turn out?
Well, basically like most litigation, it settled, so we didn't go to court formally, we didn't have a trial or anything, and unfortunately the surviving spouse had to pay off the ex-spouse, so it was a very unhappy circumstance, especially with such a long marriage. So this wasn't a recent marriage, it was a 30-year marriage, so you could imagine her surprise when she learned that the ex-wife was still named as the beneficiary. Yes, sir?
In the case of a deceased beneficiary, would that person then inherit those assets? And they would travel through to their beneficiaries, or are they deleted?
It depends
Or
on the
in the case of
nature.
the mother, if you left your mother on it,
Yeah,
it's gone.
it depends on the nature of the beneficiary designation form, and also sometimes an insurance contract or the retirement plan. Often it'll say if someone passes away and they're named as a beneficiary, there's an order. If you have a spouse, then maybe it goes to the spouse or the child, or payable to the person's estate.
They may have different terms on where it goes if that person is deceased. So, and it may end up going to an estate, but then maybe your estate, which puts you in a probate situation, and maybe all your other assets were payable on death or in a trust. And now all of a sudden you have an estate because the beneficiary designation ends up being your estate on a life insurance contract that you forgot about.
Really important to note that the beneficiary designations on your accounts override whatever your will or your trust say. So you definitely need to make sure that you're checking them frequently. And I know I go through beneficiary designations with my clients as well every time, as soon as we finish the rest of their estate planning documents, to make sure that everything is going where we want it to go.
Yes?
Is there a difference between transfer on death and payable on death?
No, it's essentially the same.
All right, next up is a trust. So we use trusts a lot. Trust property is not probate property. Trust property instead is managed by a trustee. Trusts can be revocable or irrevocable. Revocable means like you can revoke it during your life. You can change it, you can make amendments, you can do whatever you want. You can take all the property back out if you want. An irrevocable trust means that it's set, it's permanent. You cannot remove the property once it's been in there unless the trust document specifically says you can, and sometimes you can't make any changes to the documents at all. trusts can be created during your life and funded during your life, or you can write them in your will to be funded and come into existence after you pass away.
Does anyone have any questions about trust? I mean, revocable trusts have become probably the main estate planning document. When I started practicing law over 25 years ago, I would say about 90% of people used wills as their main estate planning document. Now I would say that for retired people, maybe about 60% of the people that I work with, or 80% of the people that I work with, want to use a revocable trust as their main estate planning document, largely because they want to avoid probate. They want to have a private disposition of their property. In probate, you have to file an inventory. It's a public proceeding. You know, there are costs associated with probate that you don't have if you have a trust administration. So there's been a real shift towards revocable trusts. Both of them work essentially the same way. If you're able to select how you want your property to go. The only distinction between a revocable trust and a will is the probate avoidance.
Why would somebody ever want an irrevocable one that would never get?
Yeah, so those are very rare. They're used by people who want to get assets out of their estate. So they may have a taxable estate for estate tax purposes. So they want to get assets out to other people. And then sometimes people use irrevocable trusts in Medicaid planning. That's a very complicated area of the law beyond the scope of this seminar, but Medicaid planning uses irrevocable trusts often.
So is a irrevocable trust the only, shall we say, guaranteed way to avoid probate?
No, it's guaranteed that you would avoid probate if you put your assets in a revocable trust, not an irrevocable trust, and you keep them there until you die.
So either of those two trusts would avoid probate?
Correct.
Right.
Yes.
And nothing else will?
Well, beneficiary designations avoid probate, but there's no real structure. There's no one that's handling your property. You just designate someone to receive property. I'm gonna go back there and then I'll come to you.
So if you have a trust, do you still need a will?
Almost everyone that uses a revocable trust as their main estate planning document will also have a very simple will.
Okay,
And all the will does is appoint a personal representative, and it says, if I forgot to put some property in my trust, send it to my trust at the time of my death.
Brian, can you explain what you mean by put things in a trust?
So when I use that term, all I mean is you've titled an asset, an account typically, in the name of your revocable trust, rather than in your own personal name. So instead of it listing Jenny Shan as the owner, it would say something like Jenny Shan as trustee of the Shan Revocable Trust.
Right. And you can put that on your bank accounts. The titling is trust, but your checks can still be in your name individually. It doesn't have to be on your checks. You don't have to sign as trustee on your bank account. But your title of your account is in the trust so that it doesn't go through probate. It stays in your trust as a trust asset. So usually when you work with an attorney like Brian and Maggie, they will help you identify the assets that need to be titled into the name of the trust, but then you need to go ahead and do that by contacting those companies and changing the title into the trust.
And typically your attorney will give you a letter or some kind of memo that will give you instructions, so you can just hand the instructions to your financial institutions, and then they can help you prepare the appropriate paperwork. Yes, sir.
What about real estate property? I don't think I have my wife listed as a beneficiary on her house.
Yeah, so do you own your house jointly? Yeah, so you don't need, if you have
Okay.
joint ownership, then you're fine on the first death.
Okay,
Just on the second death, your house will go through probate.
okay.
Yes, sir.
What if you, spouse and you end up, if you started a trust, or had a trust for your children with all your property in it for the children, does that prevent a nursing home from taking everything you've got?
Yeah, so that's a very complicated topic, and the short answer is you can give away your property, but then you've given away your property and you don't have control over that property. So you'd have to work with someone who would assist you with some Medicaid planning.
Well, that was another question I had. If you did start a trust and you would set your children up as owning the property, and then you got ill, do you have the right to sell that property, or is that up
If
to your
you've given it,
children?
it depends on what your trust agreement says, and you're probably relying on your children to be nice to you. If you wanna do that,
Well, that's why I'm
might be
here.
risky.
That's why I'm here, to find out these things.
That's a very complicated topic, because there are laws that restrict, your eligibility for Medicaid if you've given away assets within a particular period of time, so there's a look back period. So one of the things, if anyone has any, I don't do any Medicaid planning.
I do.
Maggie does some Medicaid planning. If, you have some detailed questions about that, Maggie'd be happy to meet with you and go through that on a no obligation basis.
Okay.
And I usually caution my clients, I don't know, maybe if you do, but, nursing homes or assisted living homes really like private pay. And so it can be a little bit tricky sometimes getting into the place you really wanna get into if you don't have any assets. So you just have to keep that in mind too.
There are limited nursing homes that will take a Medicaid patient, and typically they will limit the number of Medicaid patients per facility. So if you have the ability to pay for care, you're gonna have many more options than if you've impoverished yourself by giving away your assets.
If I remember correctly, it used to be a 5-year look back, is that?
There's a
is it
five-year look
Okay.
back.
It was 5, I thought I heard it was 7.
It's fine.
Was there a question over here?
What are the fees to, for a trust?
So, the reason we tell people that we have a no obligation initial meeting is that every circumstance is different. I used to, years ago, tell people this is what you should expect for estate planning, and I find that then everyone thinks their circumstances are simple, just straightforward. And then you find out that there's 2 ex-spouses, kids from multiple situations, property out of state, a condo in Florida. So what we do is we're happy to meet with anyone. I don't say that that's a free meeting, it's a no obligation meeting. You're able to get to know us better, you're able to get all of your questions answered. If at the end of that meeting, we'll have enough information to provide you with a proposal for whatever it is you want us to do. And if that proposal doesn't align with your expectations, you can walk away and you'll never get a bill from us for anything. So I find that's a better way to answer the question. Fees are all over the place at all different kinds of law firms, and trust can be very simple or very complex, and people's circumstances can be dramatically different. So if I threw out a number, it would probably be wrong.
So is it like a monthly fee? Is it a flat fee? Is it?
Typically, we charge a fee for a flat fee for the documents that we draft and the meetings that we're gonna have, and we try to give you an all-in number, so when you sign on, you know exactly what you're getting yourself into. And, there is no annual maintenance or, an annual fee. But if in 5 years you wanna make changes, then it would be another project and we'd give you another fee estimate.
So, for example, if I put my house in the trust, and then 5 years from now, I decide I wanna take it out because I wanna sell it, are you involved, is there a fee there?
We wouldn't have to be involved in that kind of transaction. We could be involved if you wanted us to be, but we wouldn't have to be. And you are free to sell and transfer property in and out of your own revocable trust.
And then upon my death, are there fees then for?
So there would be fees for trust administration work that we would be engaged to do. But you wouldn't have to work with us. You could go to any attorney and your trustee could select anyone to work on the trust administration. There's no obligation to us.
We have to be.
Another great benefit of revocable trusts is in managing your property, the successor trustee is immediately powerful once you pass away. So if you have probate assets and you need to file things with the court, you have a period of time where no one can handle your assets for you because there's no personal representative appointed by the court yet. And so sometimes that can take months, and then no one has the legal authority to manage your property. The good thing about the trust is that, again, once you pass away, that person immediately steps up and becomes trustee, and like right at that minute, basically, is empowered to manage trust assets.
So what if you've given someone power of attorney, financial power of attorney, they don't have that when you pass away?
Correct. Yeah, so when you pass away, your financial power of attorney dissolves.
Oh.
So no more power under that document. They shouldn't be doing financial transactions after your death. Yes, sir.
Well, if you do put your property totally in a trust for your kids, you're saying they basically own it then. Then who pays the property tax?
If it's an irrevocable trust and you've given the property away to your kids who are designated as your beneficiaries, the trust would be the owner of the property and the trust would be responsible for the payment of the property taxes. But if the trust doesn't have any cash, it's probably the obligation or in the best interest of the beneficiaries for the beneficiaries to come up with the cash to pay the property taxes.
It's pretty complicated.
It can, so trusts are used for all kinds of purposes. They're used to pass assets after you die. They're also great, and we recommend them very strongly for people in second or subsequent marriages. They're very effective at helping manage relationships, especially if you have children that are not all from the same relationship. In some situations, they can provide protection from creditors, whether that's protection for you or protection for your beneficiaries later. That depends on what the document says. We also use trusts to provide for chronically ill or disabled individuals. So that could be, maybe you have a grandchild with autism who needs daily support. You can fund what's called a special needs trust to provide them with supplemental income that the government does not count towards their available assets for providing government benefits. So you basically get to have this like little account on the side that your grandchild could access to give them like extras, like a fun trip to Disney like once a year or something, that the government wouldn't pay for itself, but still the government would provide the child with the daily living accommodations that he or she would need. We also use them to minimize federal estate tax liability. At this point, the estate tax limit this year for one individual is 12.980 million, so like 12.9 million. It's very high, which means if it's a married couple, you're almost at 34, 35,
26.
I can't do math, guys. I went to law school for a reason. It's not my strong suit, but yeah. But yeah, 26 million for two individuals. So right now, that is not a big major concern for us because not A lot of people do not have that much money to worry about. But for our clients who do have that much, we do use irrevocable trust to plan for their federal estate tax.
Yes, sir.
That sunsets at some point in the near future, right?
It does.
Yeah, so on January 1, 2026, that higher exemption amount will go away. It'll reset at a lesser amount, based on $5 million adjusted for inflation. People are estimating that would be about 6.8 million per person.
So again, it's still pretty high.
Your will can create a trust as well, right?
It can.
If that's the case, do those assets still go through probate before they can go into that trust?
Yes.
Okay.
All right, all you.
The benefits of a corporate trustee. So you can, as we mentioned, you can name your family member, you can name a friend, you can name anyone you'd like to be your trustee on your trust, but you can also name a corporate trustee. Typically, if you were to do a joint trust with your spouse and put all your assets in it while you're living, you would what's called self-trustee that. So you just name yourself as trustees. There's nobody involved but you. But you need to have someone in place in case you become disabled and unable to act, or you pass away. And someone needs to be able to take the reins of the trust and act. So typically in that situation is when you would name potentially your family member or your friend. But if you name a corporate trustee, that's what we do. We have the experience, the expertise, the continuity, objectivity. We've done this. This is our role. And so what I like to say is family dynamics can be a little tricky. And so when someone passes away, when a parent passes away, sometimes those kids, you think they get along great until their parent passes away, and suddenly you find out that there's a little more friction than you thought. And that's where we step in and bring some opportunity to take the conflict at us, which is nice. So instead of them being mad at each other and grieving, they can get mad at me, and that's okay, because I can do it. I know I'm responsible for everything. We've done it before. So we're a good way to kind of calm some family dynamics sometimes. We also, of course, have our own deep resources. We have investments in-house. We have financial advisors in-house. We have operations in-house. We have all of our administration is in-house. So we work on every aspect of the trust in-house, but yet if we need help, we have the state attorneys that prepare the documents that we work closely with. And if there's an accountant that is tied to the account, we work with that trusted advisor as well. So we don't try and take from our COIs, our centers of influence, who are doing that role, but we work jointly with them to make sure that we take care of everything for the trust.
If your trust document names a corporate trustee and that corporate trustee merges with another
Interesting. Great question. Really great question. Yeah.
Does it
So
need to be rewritten?
no, typically not. Typically the documents will have terms in there that state if that company merges or becomes another company, they will be the new trustee. Correct, Brian?
Yes, yeah, so in most cases, you shouldn't have to update your document, and the name in the document is just so, it's identifying the institution, and everyone will know that, the institution had a different name, so. There's a lot of documents that are floating around that name banks that have been gone for years, like M&I Bank, First Star Bank, First Wisconsin Bank, so no, you don't have to update your document.
Yeah, so I've been through 3 mergers from M&I to BMO and UB&T to State Bank of Cross Plains, and now State Bank of Cross Plains to Lake Ridge Bank. And each time we had legal counsel come in and review all of our documents to make sure that we could continue to act in that capacity. So we make sure that there's not gonna be a surprise. So you're safe in naming the bank as it is, and if it changes, then it should be fine.
You have a question?
Along those lines, that would be covered and then it would automatically transfer over. But if you make a change on the, say on a will of a party in the will, can you change that by codicil or do you have to do the entire will?
No, you can change it by a codicil or an amendment to a trust. You don't have to rewrite the entire document. So if you wanna take out a niece or nephew or you wanna add in a grandchild or some other family member as a beneficiary, you don't have to redo the entire document. So I think we're gonna try to get through the last slides here and then we'll stay for questions.
Okay, so marital property agreements are also pretty common. We recommend them for most of our married couples. It basically, our standard document just explains what Wisconsin law is and basically says that yes, everything we own is marital property, just like Wisconsin says. If you've got more questions about that, we can answer that individually.
Yeah, marital property is a complicated topic, but if you've accumulated most or all of your assets during your marriage, likely your assets are all marital property.
Your financial powers of attorney. So these documents, all powers of attorney, are effective only while you are alive. And by signing these documents, you do not give away any power. You just also authorize someone to do the same things that you can do. So you keep everything that you can do, but somebody else can also do it too. Financial powers of attorney are really helpful, especially if you're gone on a trip or you are in an accident and in the hospital for some reason and like can't manage your own affairs. Your agent for finances can step in and handle those things for you.
And I will mention that State Bank of Cross Plains, we can act as financial power of attorney as well.
That is really good to know.
Yes, we have a question back there?
And a durable power of attorney, do you need that for when the person dies, that there's, okay, because we've
No,
had a
so
couple situations.
durable power of attorney just means that it's effective now, and it's effective even if the person becomes incapacitated. So if you have Alzheimer's.
Okay.
But it would terminate at the time of a person's death.
So what takes over when a person dies?
So either the personal representative, if you have a will.
Okay.
Or a trustee, successor trustee in a revocable trust. And if you have neither of those documents and you only have beneficiary designations, then you have not nominated anyone to handle your final taxes, to deal with your property. There's no one that you've nominated if you do not make a nomination in your will or in a revocable trust.
Okay, but I just had a friend who went through that, and she was nominated as a person to take care of her father's will in the will.
Yeah.
But she had to get a durable power of attorney in order to take over and start paying his bills and get everything taken care of. She had some legal issues with it, and she's the second person I've heard that had that issue.
Yeah, they maybe wanted to see, I don't know if she was specifically named in the will. If she wasn't, maybe they wanted to see that she was the financial power of attorney, just to have proof that she was the person that the deceased individual wanted to handle the affairs.
Okay, she was told she had to have durable power of attorney. That's why I asked the question.
Yeah, durable power of attorney, it terminates at death, so I don't know why any attorney would ask that, but maybe some financial institution asked the question.
Yeah, unfortunately, a lot of banks, especially lower level staff, they don't know the law very well, and so they. Not you.
No, but you're right,
Yeah.
and it's a topic that they don't deal with every day, so they don't always know, but financial power of attorney does see it.
Yeah, so if you're dealing.
No, the fact that you're here.
If you're dealing with a death situation, it's best to seek out the people in the trust department at that specific institution, or someone that's a higher level individual than just the person answering the phone.
Right, bank manager, someone higher up usually will understand
Yeah.
that a little bit more.
And a trust group is incredibly helpful to have, absolutely.
Our staff will be the first to say they're not an attorney.
Yeah.
So you can grant broad authority or limited authority to your agent for finances. It just depends on what the document says. So when I'm discussing that with my clients, we go through the form, paragraph by paragraph, to make sure that they do want to delegate that power to their person. And it's all just depends on what you want. All right, healthcare powers of attorney. So these are also incredibly important. These also are only effective while you're alive, and they designate someone to make healthcare decisions on your behalf. But they do not become effective until you are declared to be incapacitated by two medical professionals, usually physicians. So you are designating someone to make decisions for you, but you make those decisions until you are not capable of making them anymore. So you're not just giving away all of your rights again. It's just naming someone who you trust to make those decisions for you when you no longer can.
And people have this misconception that if you're married, that your spouse is legally authorized to make your medical decisions for you, and that's not the case. So although the doctors might listen to the spouse and take the spouse's direction into account, the doctor is not legally obligated to follow the direction of the spouse if there isn't a healthcare power of attorney in place. So it's very important, if you take one thing away from the seminar, and you decide you don't wanna, do a comprehensive estate plan, you should really still do a healthcare power of attorney. It's a state form, you could fill it out yourself. Many medical groups have, they'll provide you with a copy of the form, and I strongly encourage that if you don't have a healthcare power of attorney in place, that you take the time to put one in place.
I agree. Two quick topics on that. One, if you know anyone who has children that are turning 18, they should have a healthcare power of attorney when they go off to college. A lot of people forget that. It's very easy to forget that once you turn 18, you don't have anyone that has control over your health anymore. And then two, if any of you know the Terry Schiavo story from years back, that story was a prime example, spotlight right on not planning for healthcare. And she ended up at like 27 years old having a stroke in 1990, and she ended up in a coma. Her parents and her spouse fought for 15 years on who had the right to determine her health. And they went through 14 appeals, many hearings, many other legal things that I'm sure you're aware of, until they finally removed the feeding tube, and she passed away 15 years later. So it happens. The court will decide who makes that decision, but that means those two people were fighting that whole time on who gets to make that decision.
Question?
A financial power of attorney means that, and I'm asking, so I wanna make sure I'm clarified in my mind. A financial power of attorney says that I still have the right to make financial decisions, but this other person can also make them.
Correct.
A medical power of attorney says, I'm still making all my decisions until I'm unable, and then they will come in. They can't make it at the same time as me, if I'm
Correct.
capable.
Correct. Yeah, there are financial powers of attorney that spring into effect like a healthcare power of attorney, but most people who come in typically opt to have a financial power of attorney that's immediate, that's in place, and the person that signs it still has all of the financial powers that they always had, and then their agent has the same set of powers. Yes?
I've got two questions. One, on the financial power of attorney, do they expire? Like if one was drafted years ago and the seal of,
The notary?
is really faint on the paper,
Yeah.
but does that ever?
I mean, technically, they don't expire unless the document says they expire, but the older they are, the less reliable they are, and usually if you have a very dated financial power of attorney, you know, more than 10 years old, we definitely recommend that you update it, even if you're not changing who you're appointing.
Okay, if the person who it is applicable to is incapable of filling that out, because she's 102.
Yeah, the old one is still legally effective, you just might have to work to convince a bank that this is the most current financial power of attorney.
Okay, and the second question I have with the healthcare power of attorney, is there, how many times do you have to produce it? Because it seems like every single doctor you go to, they say, get it. It's like, well, why can't we just have it on file somewhere?
Yeah,
So they can be
and you can have it on file, and you can upload it to your MyChart, if you have a MyChart account at your medical provider. The problem is, not so much with the law, but with the medical institutions that you're dealing with. And you might be going from the UW Medical Foundation Doctor Clinic to the Meritor Hospital, which is a different legal
They don't
legal
talk to each
entity, and they don't talk to one another very well.
So there isn't a database somewhere, like, kinda like your immunization registry?
It would be great if they had that, but they don't, and so that's why it's very difficult. So you might be in an accident in Minocqua. Well, you're at the hospital in Minocqua, they're not gonna have your document on file there, so.
I hope they have a statewide system.
That's a great question.
Yeah, probably money and lack of will.
That's a good idea, that's what's gonna happen.
Yes.
Yeah, say we're both in an accident and I had named Dennis for my power of the healthcare, but he cannot be it now and I cannot be it, what happens then?
Well, you can always name an alternate, and you can name multiple alternates, so we typically recommend that if you have other family members, name them as alternates. So Dennis would be the primary for you and you for him, but then you would name someone as a secondary. And you don't have to name the same person, so if you wanted a sibling and Dennis doesn't like your sibling and he wants his sibling, you could have different alternates. Yes, sir?
It's probably directed more at her, it might be a little off the subject, but you're dwelling on everything being in will, everything's spelled out, who's power of attorney. Something happened to my wife and I, we have our safety deposit box here with our will and every single thing listed. Who has access to it, or how do you give right to anybody to have access to that safety deposit box?
That's a great question, and we run into that issue where we can only do what's called a will search. So we have to be supervised, and we can go in and we can find your document in there, and we can take only that document to be filed with the court. So it's a great question. If
And
it's
then
kept
you
in your safe
notify.
deposit box, it can be hard to get in depending on the
Jenny,
circumstances.
can you designate a beneficiary on a safe deposit box?
Yes, well, they're not a beneficiary, but you can have, I don't know if you can do it, maybe there's a banker in here, but I don't know if a beneficiary can
Phyllis
be
or
named.
Michelle, you wanna take that one?
No, you can name a joint owner,
Well, if you have
or
a
you can put it in
second-
your trust as well.
Right, so if you have a trust, you can name it in the name of your trust, and then your successor trustee can go into that safe deposit box. If you have a will as your document, and you put it in there, and if you have you and your spouse and you're both deceased, well, then you can do what's called a will search, and we can get that out of there and filed with the court, so the person can be named, and then they have authority to go back there.
We can't do that if we're dead.
Right, so what happens is then the bank will allow someone to go in there and do the will search. So
Okay.
usually a family member will say, well, I don't know where the will is, maybe it's they have a safe deposit box, check with the bank, and then the bank will allow just the will search, it's a
Right.
supervised search, so it's just for the will.
Right, so even though we have the second key, you can still get in.
Well, if we couldn't get a key from a family member, we could drill if you're both deceased, we would just have to drill it
We have
and
the
get
other
it out.
key, so.
Yeah, great question, cause that does happen.
That's, can I just add to that?
I know it's a
Yeah,
little
that'd
off
be
the
great.
wall.
If you're doing that, make sure you're telling your family members where your key is.
Okay, that's helpful, exactly.
Michelle, do we also still put a copy back in, the box of the will?
Yes.
So a personal representative can't get into a safety deposit box?
They can when they're named by the court.
Yeah,
But it-
after they get appointed formally by the court.
Right.
But
But if-
not, if they're just named in the will and they haven't yet gotten court approval, they can't get access to the safe deposit box.
Because they don't have authority yet.
With regard to wills, how, do they have to be filed through, like, a lawyer or something to be valid, or do they go by date, or how?
So you don't, anyone can make their own will as long as they follow the formalities, and there's some very strict rules about what your will needs to contain and how that will is signed and witnessed. But you can, there are online services that I don't necessarily recommend, but there's no requirement that an attorney draft a will.
And they are considered legal.
If you execute them properly,
If you have like two different signatures, we get it authorized.
if you follow the procedures correctly.
Yeah, and if Wisconsin has a set of laws that govern how you need to execute a will and have the will witnessed, and other states have different processes. So just because you know how they do it in Arizona doesn't mean you know how they do it in Wisconsin.
Is it that important to have a will and a safe deposit box? We just have ours in there with all our funeral arrangements and all that.
Your original will.
Yeah, there is a benefit to having the original will. It does make starting the probate easier, so it doesn't necessarily have to be in a safe deposit box. You could get a fireproof box at Farm and Fleet and put it in a fireproof box, or put it somewhere safe.
My trust and estates professor says she keeps all of her important documents in the freezer, because apparently that's your like natural fire safe box at home. So, it's nice.
So power doesn't go out.
Assets are frozen.
Just know that some of those are not waterproof.
Yeah.
I wouldn't hardly.
Oh, sure.
I got a funny question. If you have 2 or 3 wills and a trust, are they all valid?
It depends on what they say. So most wills say, I hereby revoke all prior wills. Yeah. Yeah.
All right, so we definitely recommend you have powers of attorney in place, especially healthcare powers. If something happens to you and you do not have these documents, the only way for somebody to come in and manage your affairs while you're alive is to petition for guardianship. And that means they have to go through a court process. They have to provide a lot of different people with notice. They have to go in front of a judge and say, my father, mother, they're no longer able to take care of themselves, and court, please appoint me as a guardian. It's a slow process. It can take up to 2 or 3 months. It's expensive because you have to hire a lawyer in order to appear in court to manage this process for you, because it's really finicky and it's complex. And so I definitely recommend powers of attorney for sure to avoid guardianship because it is a huge pain.
So I think we have just a few more slides here, and then we'll wrap it up.
So a declaration to physicians or a living will is a document that's often coupled basically with your healthcare power of attorney. It essentially states your desires and provides guidance for your healthcare agent when making decisions for you at end-of-life situations. It also provides guidance to a physician if you don't have an agent there or active. And it's got really specific questions. Would you want life support in this situation? Would you not? And it's, again, not everyone completes those, but they are just an extra document for guidance for people if they don't know your wishes and you haven't had that conversation. when should you update your estate plan? Generally, birth or adoption of a child is a good one. Whenever you are divorced or married, those are good ones. Someone passes away, you have a major change in life circumstances, you decide to name someone new, or your designated PR, or all three of them are no longer around or can't act in those positions anymore, that's when you wanna consider updating things and making sure that everything's still in order. We also generally recommend that you come in and talk to us about updating wills every 5 to 10 years. As you know, the law does change, and we can't predict what the changes are going to be in the future. And so there are some pretty serious impacts that do come out. I know in 2019, the Secure Act had a major changes in retirement accounts, and so we had to adjust our wills and documents and trusts pretty significantly in order to comply with that act. And so we definitely recommend just getting in touch with us every 5 to 10 years to make sure that you're all still good to go.
And for those of you that have estate planning documents in place and you haven't looked at them for years and years, pull them out and look at them. You'd be surprised what you'll find. It's very frequent, people will come in and they'll say, I didn't remember that I named my old next door neighbor as my personal representative, and I haven't been friends with that person for 20 years. So yeah, take a look at your document from time to time. Memories fade, and we recommend it at least on every 5-year basis. Pull it out and make sure that the names are all the same, and your wishes haven't changed since the last time you updated your document.
Could you summarize the 2019 changes? You said that something is 2019 changed a lot?
Yeah, I'm sure you've heard about now when IRAs are rolled over or not rolled over to a child, they have to be distributed within 10 years. That's a new thing. That was the Secure Act. There's a lot more in there. I definitely can't summarize the whole thing, but that was the major, that was a major change.
That's a major change that would
How
be.
is that now, IRAs?
They have to be distributed entirely within 10 years.
Inherited IRAs used to
So
be
you
able to
can
go
go
for
do
the
it for the
lifetime.
lifetime any longer.
Right, and now they're shortened to 10 years. There's certain exceptions, but a lot of them for children, it's 10 years.
What if they're not distributed? You don't know about that.
They're not distributed by December 31st of the 10-year span, then you're gonna have to pay penalties. And they'll be really deep, I'm sure. I
Yeah,
don't
and
remember what they are
this
exactly, but-
is only, the changes, if someone is already in the pay, they're already getting distributions out over their lifetime, and the death occurred prior to some particular date in 2020, they don't have to now accelerate those payments over the 10-year time frame. So it only applies to deaths that occur after a particular point in time in 2020.
Good point. Yeah. So it doesn't change ones that are already out there inherited. It's the new ones that die after this certain date, then you have to do it within 10 years. And you don't have to take it an equal amount each year for 10 years. You can take it in whatever denomination you want, but it has to be withdrawn within that 10 years.
Secure 2.0 that's coming out says you have to withdraw something at least in years 1 through 9.
Yeah. We have a conference coming up on that, and I haven't done it yet. Okay, well, never mind.
It doesn't have to be equal. It doesn't have to be equal, but you do have to withdraw
You have to
something.
do something every year. Oh, that's neat. Okay. See, things do change. You have to talk to your
Well-
attorney or you're gonna miss it.
We hope you learned something tonight. If anyone wants to come up after the presentation, we'll stick around for a while, and then if you prefer to get together at a later date, just reach out to either Maggie or me, and we're happy to get together with you at your convenience. So thanks for coming tonight.
I just wanted to take a minute to thank you as well for coming out tonight. As you can see, we try through Prime Time to provide you with some great professionals so that you not only can learn what might be important to you financially, we want to be a financial resource for you. And so if you have other topics you'd like us to have people speak on, make sure you let us know. You can email Dave or myself at primetime at sbcp.bank, soon to be lakeridge.bank, same email otherwise. We just are always happy to provide these opportunities for you. And so thank you for coming, and thank my husband Butch for manning the door, and Dave for getting the food and the technology going, and but really thank all of you, and we're glad you're here tonight.